to yourself.
For which reason?
Because you're fascists. Rebel News is a fascist organization.
You don't think that he should disclose his relationship with the convicted sex trafficker?
He's standing beside someone.
No, I've been seeing also another photo hanging out in the grass.
You should be ashamed of yourself. Get away from me.
But like, you don't think that he should actually be accountable of certain things that he did? He's the prime minister now.
What did he do?
Just answering the question to disclose the relationship. That's it.
I know what Rebel News is. I have no respect for you. It's yellow journalism. Turn the camera off.
I don't know even who I am. So you're ready to just call names to someone? Thank you for the finger. You did a finger to me and call me a fascist. What? Our message on our talk.
For those of you who don't know, that is Alexa Lavoie of Rebel News. And she's awesome. She's the one who got shot in the leg, point blank, not with a gun, with a tear gas canister gun during the Ottawa trucker protest. Donning her journalism, media, and credentials and microphone that said Rebel News. And I don't know if it was RCMP, I forget exactly who it was, unleashes on her upper thigh with one of those, it's like a can of tear gas into her leg. That's Ottawa. I think I'm fairly certain that's Ottawa. I don't want to make a mistake. Hold on a second. That is Ottawa, right? Let me just play this for one more second here.
I think it's appalling. I think you should be ashamed of yourself.
I don't know if it's got Mr. Smoke in the backdrop. Encryptus, can you double check if Mr. Smoke is in downtown Ottawa? It really looks like Ottawa. Maybe Mr. Smoke, and what's that other thing we got back there? I don't know what that is. Whether or not it's Ottawa, that is representative of the Ottawa attitude, people. Rebel News, you heard it there, people.
Yes.
It's in Ottawa, right, Mr. Smoke?
Yes, it is.
It's a fascist organization, people. Rebel News. How a media company could be fascist? Maybe I guess technically it could be fascist if they have an unholy alliance with the government, because Mussolini-esque fascism is the marriage, or I guess it's a three-way between government, media, and big corporations. So I guess if Rebel News was like the CBC, state-funded with a holy alliance, then I guess they could be a fascist entity. Idiotic. This is what's going on in Canada, people. We're going to get into it even more tonight because it's wild. And before we even get into the show, good evening, everybody. Viva Fry. I did a parkour race today. I mean, it was sort of like in a playground with my kids parkour instructor. And I think I did very well. If you haven't seen it, you can go watch today's vlog where I talk about the rogue activist judges blocking Trump's attempts to invoke the Alien Enemies Act of 1798, which we will also talk about tonight. So I got my exercise in today, but if you haven't been following what's going on in Canada, it's not encouraging. It's actually exquisitely discouraging. And another element of it. Am I in my, hold on a second, get me out of here. That's not the one I wanted to bring up, but I'll bring it up now in a second. Another element of what's going on in Canada, boycotts and protests against Elon Musk. I'm going to bring this one up anyhow. Here, Art Candy, Space's host trying to find common ground, dubbed a, quote, liberal pundit by Afternet, smack talker. The country is doomed if we don't communicate. Oh, it's hilarious. It's always the people who virtue signal the hardest in their avatars that act like the biggest assholes on the internet. I will be the first to admit I am saucy on Twitter, but I'm not going to write in my profile, be kind to each other, when I'm calling Mark Carney a 3-passport carrying whore. We're still a few minutes into this, so I won't get into the MFing whores. But Art Candy posts, they're protesting Elon, Musk, and Tesla up in Ottawa, Canada. Love our Canadian neighbors. And then you go to the post. Look at this. First of all, this is the most lackluster group of jackasses I've ever seen in my life. Second of all, what the Encryptus, tell me when the 8 minutes are up so I can drop some F-bombs. What in the name of sweet holy hell is going on? The woman's wearing an N95 face mask. We're in 2025, people, and she's outdoors. And this is the level of abject insanity that's going on in Canada. Now, in fairness and credit to Canada, what do we got here? A half a dozen jackasses? No, we got maybe a dozen. Not a baker's dozen. what's it called when you got a stingy baker's dozen? 1, 2, 3, 4, 5, 6, 7, 8, 9. I'm not counting that kid on the right. Who the hell brings their kid to a protest anyhow? This is what's going on in Canada. And like it led to an interesting discussion. Because I've long said, if lefties, capital D Democrats, capital L liberals didn't have double standards, they'd have no standards at all. Got into a long I gave up after a certain point with Unlearned 16, not because I have anything against her. She was on last week. We had a good discussion. I was like, well, do you really think Elon's going into the green energy for the sake of the environment? I don't care. I don't know. I will never be able to know someone's intentions behind their outward actions. You can suspect and you can accuse, and sometimes I do. But the idea that you have your alleged green energy loving, climate crisis obsessed idiots wearing N95 masks outdoors 5 years after COVID, you have them protesting an American company in green energy that is supposedly, by their own rules, reducing greenhouse emissions, which are the be-all and end-all of the climate crisis conundrum, picketing and protesting the guy that's saving the environment. That leads me to believe that you are all a bunch of rapacious idiots. And by the way, they are protesting the American company operating in green energy, so that what happens as a result of that? So that they benefit China EV, China battery makers, the greatest single contributor of greenhouse gases on Earth. Now, I personally do not believe that green vehicles, EVs, are better for the environment than coal-burning vehicles or gas-burning vehicles. I don't believe it. All things considered, you lefty buffoons, you think that the cars get themselves over here, that the minerals just magically appear like unicorn farts. Those rare earth minerals are extracted in the most violative of nature circumstances in third world countries that you don't see. You mine them from third world countries where you've got people engaged in human slavery, operating under the most horrendous conditions. The runoff and environmental pollution is disastrous. Then you got to go mine them, get them, refine them, turn them into batteries. Then you got to ship the batteries over to the car factories, assuming that they're even manufactured in America if the vehicles themselves are not made overseas, and you got to ship the cars in. You think all that happens without burning a shit ton of fuel? You know what the number one polluter is if you go by greenhouse gases? Ocean freight liners. So, and that's what happens when it's done. What do you think happens with those batteries when they break down? People chuck them everywhere. They go into landfills. They break, they leak. You get all sorts of nasty chemicals spilling all over the place. So I don't believe that they're any more environmentally friendly than the traditional gas burning cars. But operating on their own rules, by their own rules, they are. And so these idiots are protesting, boycotting, picketing, imposing 100% tariffs on the American employment company, operating in green energy, reducing carbon emissions and greenhouse gases, so they can then divert all of that money and pollution back to China. When you shut down the economy of Canada because you don't want to produce oil locally, you're not preventing pollution, you're outsourcing pollution, you raging jackasses. That's what's going on in Canada. Oh, good evening, everybody. We're going to have one hell of a show tonight. Barnes is going to go ape poopy on his experience in Seattle. We're going to get there. We got a great show, and I got some other stuff that I want to talk about. But before we even get there, in fact, let me make sure, because I'm totally neurotic. I'm fairly certain I checked off that box. Yes, it does. This video contains a paid promotion, people, because it does. And that is the wellness company. Now, I've figured out how to get past the not having audio on the B-roll. I uploaded it unlisted to Rumble, and now this is the B-roll.
So we started pulling grants, and we could see that there was funding going to aerosolized COVID vaccines. But that wasn't the most shocking discovery that we made. This is what led us to the discovery that our government's funding research on transmissible vaccines or self-spreading vaccines. They're developing vaccines that would essentially act like a live virus, where it could basically replicate itself into new hosts.
Now, people, the globalists will never stop. They are pushing more airborne vaccines, no needles, no permission, just exposure. The last administration quietly funded grants for aerosol vaccines, a delivery system that could infect us without consent. Millions were forced into the mRNA psyop. Cases of a number of adverse events, myocarditis, blood clots, immune damage, have skyrocketed. 8 states are in the process of banning these shots. The Trump administration needs to make sure this tyranny hasn't been released on the public. Dr. Peter McCullough of the Wellness Company has created the ultimate spike detox with 4 times the nattokinase plus bromelain, curcumin to help break down the spike proteins and support your body's natural recovery. Experience the formula approved and used by Dr. Peter McCullough, a top freedom-fighting cardiologist who risked it all. You head over to TWC. Support your body's natural recovery.
Now I hear myself.
Experience the formula approved and used by Dr. Peter McCullough, a top freedom-fighting.
I forgot to get this thing out here.
That's me. Now I just lost my train of thought. Yeah, you go to twc.health/Viva. Code is going to get you, I'm going to make a mistake on it. It might be $32 off and free shipping. Check it out. The promo code will get you a good discount on it for our viewers. And then the question is, check it out. Link is in the description, people. Oh, Lordy. Who invented the mRNA? I think that was Malone, not necessarily McCullough. Viva having technical problems? No, that wasn't a technical problem. That was just I forgot to minimize the screen, and then it went to play the next video over on Rumble. So got into a bit of an interesting discussion with a number of people. By the way, if this is your first time here, welcome to the channel. We start on CommieTube, which is YouTube, Rumble, Twitter, and vivabarneslaw.locals.com. We vote with our feet and vote with our dollar and head over to Rumble. By the way, next week, this is what I should have led off with. Next week, if you haven't heard the big news, if you haven't watched Steven Crowder, I think they're going to mention it this week. Rumble is launching something like of a network type lineup all day long, where all of the, I just say I'm on the lower rung of that ladder, but some of the more prominent live streaming commentator news covering peoples on Rumble are going to go back to back all day long. And it's going to be basically like network television where you're going to have the best shows, the best programs, the best live stream commentating all day long, basically from 9 to 10, 9 in the morning to 10 at night. I don't know what the exact order is. I could just tell you that Crowder's in the lineup, Russell Brand is in the lineup, Tim Pool is in the lineup, the Quartering is in the lineup. My new time slot is going to be 4 to 5, but next week I'll be doing 3 to 4 plus, exceptionally next week. And then the week after that, it's the official lineup. So it's going to be amazing. Now, Verax1 says they better be careful. You get sued for honking in Ottawa. This is true. Hardy har. And then Tanny O'Haley says, I heard a family law judge in Los Angeles, when challenged that they weren't doing, what they weren't doing was constitutional, say Constitution's Constitution. The Constitution doesn't apply to family law. I reported him, but nothing was done. How can we get these judges removed? We're going to get to that, actually, when Barnes gets here. Because he's had that experience now in Seattle. We're watching that happen now in the Dexter Taylor case out of New York. And what we're watching with the Tina Peters in, Colorado? It's Colorado, right? Is the wholesale violation of civil rights. Nothing more and, let's just say, nothing less and a whole hell of a lot more. Over on Rumble, we got Viva. Did you hear that Dr. David Weldon was sacked before confirmation by Murkowski, Patty Murray, and Senator Cassidy from Louisiana? I did not hear that at all, actually. Let me make sure that Barnes has the link and make sure that he comes in, and then I'm going to talk about something. Banj. Yeah. You got the link? Question mark? Smiley face. And let's see what's going on over on our vivabarneslaw.locals.com community. Stingray with a $5 tip says, could Trump claim that the ADL has no standing? Laughy face. Well, the ADL, that's going to the case involving the Alien Enemies Act, or the Enemies Alien Act. The Alien Enemies Act. ADL is that's now that you mentioned it, they're represent. They've did. Oh, it's now I forgot. They're not the counsel in that. They are acting for and on behalf of the gang members that were deported to El Salvador, from what I understand. This is what I wanted to talk about in respect of the lineup on Rumble that's coming. It's a very interesting thing. Not to say that I was zooming in to see where I was in here and I didn't see my name. And yes, the ego part of my being was a little bit disappointed that I didn't make it in here yet. This is a post. It's a post from Media Matters for America. Angelo Carasone, president and CEO of MMFA, which, if they have an acronym of a name that sounds like mother effers, this is the one. Dump Trump organizer, formerly Stop Beck, onward. Tweets are mine alone. Interesting. Put out a whole thread here, by the way. And what's amazing, and it wasn't even my observation, but I've made it my own information now. I'll get to it in a second. What you can see here is clear. I'm reading the tweet. What you see here is clearest illustration why things are so... What kind of language is this? What you see here is the clearest illustration of why things are so messed up and why it cannot get any better until this asymmetry is addressed. Put simply, right-wing narrative dominance. My org, MMFA, but he's only speaking for himself, people, did this study and has been sounding the alarm for years. Some thoughts. And so you look at this and you look at the numbers. You got, I mean, the two biggest ones, I guess the second biggest is actually Ben Shapiro. Jordan Peterson, who by all accounts is a good Canadian boy. He should be blue. You look at all these names: Charlie Kirk, Joe Rogan, Russell Brand, Tucker Carlson, Dan Bongino, Candace Owens, Patrick Bet David. I saw Nick Fuentes. Yeah, right in there somewhere, 3.4. I didn't see my name, but I am who I am, and I can't be bigger than I am, and I will never be 7 feet tall. On the one hand, I said my first response to this was, it's not asymmetry in messaging. It's not narrative dominance. What it is rewarding of people who respect basic science and basic intellectual integrity. You're not losing the narrative symmetry when you push idiotic ideas that push everyone out. And I said, like, you're not going to say, you don't get to say boys can menstruate and girls can have penises and think that people are going to listen to you for much longer. And it's not an asymmetry. It's a market responding to your shit product. But then someone said, like, Viva, Rogan and Brand should be blue if they hadn't terrorized those two out of the left. And some might even say Rogan now should still not be red, even though he endorsed Trump because he saw no other alternative, because he's still quite very much on the policy aspect of things, or I should say socially liberal, maybe fiscally conservative. I don't even think he's that. But the whole point is that you push out your most prominent voices from your radical, cult-like, and I say cult-like because I don't necessarily think it fits the criteria of a bona fide cult, your cult-like members. What are they called? Apostates? You throw them out and then you say, well, why isn't anybody here? Why don't we have any prominent voices? Because you're a bunch of idiots who tyrannize, brutalize, and alienate your biggest, most prominent voices. So congratulations, MMFA. The only cool thing that I noticed with the MMFA is Media Matters for America, Viva Fry. I want to see, like, there was something I came across, and I actually saw that Media Matters actually reported on me mildly favorably when it was oh cripe. I forget what it was now, and they actually said, like, you know, Viva was saying, don't run with this. Oh, it was the story of the Black insurrectionist tweet about Tim Walz, and they were like, even some voices on the right, some conservatives. Look at these MFers. Yeah, MMFA stands for Massive Motherfucker Association. We're out of the first 8 minutes. Yeah, MMFA. Look at this. The ones who accuse others of spreading disinformation and slander are the ones who spread disinformation and slander. Right-wing media figures are spreading salacious and unsupported accusations against Tim Walz from an account known for creating viral hoaxes. This is coming from the side of the aisle that ran with that crazy lady who said that she was very much exploited by Donald Trump. And then the left goes and says, oh my goodness, there's a story breaking that Donald Trump, there's a woman who said that when he was on Epstein's Island, yada, yada, yada. But then, so I was going down to the bottom here. Some right-wing figures uncritically promoted the anonymous and baseless accusations. And then you scroll all the way down to the bottom. Some right-wing media figures urged others to stay away. Listen to this. Right-wing commentator Bill Mitchell stated he would not discuss the story until the facts are confirmed. QAnon, I mean, they got to even defame the people who are doing the right thing because they can't even give them credit. If they were to say, look at these big right-wing accounts who are actually doing the right thing, they wouldn't be able to get away with their headline, right-wing accounts are spreading salacious disinformation. Nick Sortor, right-wing social media figure, that one's mild. These allegations hold no water unless the accuser goes public. QAnon figure Jordan Sather. While I think it's totally possible Tim Walz did these things, yeah, I'm highly skeptical. Conspiracy theorist Mike Cernovich wrote the same account. Mike Cernovich is a voice of reason, a conspiracy theorist. Oh, what's that conspiracy theory? The one who played an integral role in blowing open the Epstein case. Well, what could sons of bitches? Then we got that one. Rumble streamer David Freiheit, known online as Viva Fry, called the alleged supporting evidence questionable and underwhelming in a very, very meaningful perspective. Well, thanks, Media Matters. Now I love you guys now because you spoke nicely of me. Oh. That's what's going on in the world today. Robert Barnes, sir, I think I see you in the backdrop. Get ready to rant. Robert. I can already I know it's going to be good. Because I know the week you had, and if anybody doesn't know the week Robert had, then you don't watch the Bourbon with Barnes is back over on vivabarneslaw.locals.com. Robert, you are back home, it looks like.
Yes, indeed.
How good is it to be back home?
Well, yeah, always good to be back home. The soon home will be in Tennessee. I'll be moving this summer, so that'll be fun. But good to escape the insanity that has become liberal democratic jurisdictions like Seattle.
Are you moving? I don't want pride. Tennessee permanently?
Yeah. Yep.
Oh, cool.
Yeah, moving back home to Southeast Tennessee.
Now I know that
Chattanooga.
Some people in the chat are going to start haranguing us again. We are thinking about doing something at some point.
Yeah. The annual 1776 Law Center fundraiser will be this summer in and around likely Florida. Thought about some other places, but most likely South Florida. But it'll be at least an annual tradition. There'll be other meetups and other things we do as well. But the fundraiser to support 1776 Law Center will have a dinner, looking at adding some CLE events. And things of that nature. Probably maybe do a little for those that want extra bonuses. There might be like separate bourbons with Barnes at cigar bars in South Florida, separate fishing with Viva for those that want to do those.
Shark
so
fishing.
We'll make it like a whole weekend set of events so that people get real value.
That'd be fantastic. That's fantastic. Okay, awesome. And you're gonna both you and I are gonna be at Hunley and Grobert's event in Vegas for your 51st birthday.
The America's Untold Stories are doing their meetup event here in Las Vegas, and they're honoring us. So that happy to be there to support them. They do good work. You can find they're over at unstructured.locals.com is where you can find all of Mark Robert and Eric Hunley's work, breaking down all kinds of fascinating stories about crazy cases and crazy histories and the conspiracy theories and everything else thrown in. So they're always a lot of fun.
All right, Robert, we'll go over what we have on the menu, and then I'm going to let you rant and rave about your week in Seattle, where apparently the Constitution does not exist. What do we have on the menu for tonight?
Yeah, we have the case that led to one of the most circulated tweets I've ever put out, or posts I ever put out on X, about senseless in Seattle, which took it to a whole new level. State of Washington was also doing crazy stuff all week. They were in the news for all kinds of reasons, trying to take away parental access rights in the school system, trying to threaten sheriffs that if they help the Trump administration, that the Attorney General of the state of Washington might get them arrested if they simply enforce immigration law. That combined with what Judge Parisian said in the case of State versus Benchouf, which Senator Cruz and a wide range of others expressed concern about, amongst other things that's happening in the judicial branch, where a state court judge prohibited the Constitution from being referenced in court in America. We'll get to that case. We have the number one voted on topic at vivabarneslaw.locals.com, who's the show notes producer for the show, is judicial reform and the history of judicial reform in America. The Judiciary Act of 1801, the Judiciary Act of 1802, the impeachment of Supreme Court Justice Samuel Chase, the famous statements of Andrew Jackson about the Supreme Court, the famous statements of Thomas Jefferson about the judicial branch, the actions of FDR, and what now must be and may need to be the actions of President Trump, as Mike Davis of the Article 3 Project, Senator Mike Lee of Utah, Senator Grassley, chairman of the Judiciary Committee, finally acknowledged the same thing, that something has to be done about the rogue, wayward judicial branch, of which what I experienced in Seattle is simply one more sad exemplar or illustration. For Senator Cruz's people, I will be actually getting the transcript and the audio recording of the hearing. The court wouldn't allow anyone else to record the proceedings, wouldn't allow the proceedings to be broadcast. So that's why. Well, why is it these judges always like to act in secrecy while pretending they're doing it publicly? And in between, the same judge threatened members of the gallery during the proceedings because she didn't like how they were looking at her. This is the insanity that's happening in our liberal democratic jurisdictions. We've got the Alien Enemies Act. What does that mean? We've got a federal judges ordering President Trump to give secret classified file information to big corporate law firms that serve the interests of the deep state against the president's elected will and the American people's will. We have another federal judge ordering that he import terrorists back into America. We have another federal judge ordering him to spend billions of dollars on foreign organizations and foreign institutions and foreign individuals. This is what's triggering the concern that the judicial branch has gone rogue full scale. So in the context of that, we'll be discussing the judicial reform efforts as well. We've got the green card cases, the people who think that a visa gives them a right to do anything they want. But on the flip side, those that seem to want to actually deport people for speech might need to review the cases concerning Harry Bridges. We'll be discussing that case. Nationwide injunctions in the context of birthright citizenship is going right to SCOTUS and may be decided this week. We'll discuss that case. Professor Alan Dershowitz before the Ninth Circus, which is what it should be labeled these days, more and more, Court of Appeals. They dodged a Supreme Court review, but they still made a bad ruling on the issue of sanctionable conduct. And last but not least, the Smith-Mundt Act. What is that? What does it concern? Why is there discussions of reform and remedy about it? We'll be getting into that as well tonight on Viva Barnes for the people.
Well, I guess we're going to, I don't know. We'll start with what happened in Seattle because it'll segue into everything. It's now at least 3 courts where I've heard of judges saying, don't bring in the Constitution. It doesn't exist here. In New York, Dexter Taylor, don't bring in the Second Amendment. It's the state of New York. It doesn't exist here. Seattle, there was another one, I think in San Francisco. I'm not sure where that one was. Tell everybody exactly what, first things first, when you order you're going to get the transcript or the audio of the hearing. You do have access to audio recordings, right? They'll give you CDs so you can actually hear what went down.
They are supposed to have audio recorded it. So not all courts do that. Federal courts, for example, have no audio recordings. Well, at least none they make available to anybody. They only allow transcripts from the official court reporter, of course. That's in fact, I am filing a brief tomorrow before the Pennsylvania Superior Court, the Court of Appeals there in Pennsylvania, in the McGiddy case, where a woman was criminally prosecuted because she tape recorded her own court proceeding that documented fraud by the court reporter. That's what these judges are trying to hide and cover up: corruption and fraud and abuse of power in the judicial branch. That's why they don't want to have their proceedings broadcast to the world. But they're supposed to have audio recorded it, but they haven't been producing those audio recordings in a timely manner so far, as well as having a transcript. So I'm ordering both. Obviously, we're filing an appeal in that case once the sentencing occurs. The judge was really kind. She scheduled the sentencing on my birthday, April 11th in Seattle. We should have an actual transcript. People were there, though, in the courtroom listening in live time from our Nunk video and others from our vivabarneslaw.locals.com community. And despite many of them being familiar with the problems of the judicial branch, they were still shocked to hear a judge say that overtly. That I could, and I'll explain why, how completely outrageous it is. But they were like, Senator Cruz was like, the judge didn't really say this. Yes, Senator. The judge really said it. The judge said that the Constitution of the United States could not be mentioned in her courtroom in the Benshouf case, period. Even though the statute, as a matter of law, makes the Constitution a complete defense to the charges. The statute itself explicitly does. The jury instructions emphasize in the notes, include all of these whenever the constitutional issues are present. The model penal code the law is based on requires that the jury be instructed on the constitutional limits of the law and the full defense that the Constitution provides any defendant in such a case. So this comes right from the law itself. There's no dispute about this, no question about it, no controversy about it. And yet the judge refused to give that instruction. Indeed. So this is a case in which Kurt Benshoff alleged to have committed felony stalking and gross misdemeanor harassment based on his speech and petitioning activity. So that's the concern, is the second part of that. Normally a stalking case concerns just behavior. Harassment, just behavior. It's violating trespass rules, right? Things like that. You keep showing up physically in places you're not supposed to be. It is not typically supposed to be predicated on anything that is constitutionally protected.
If I may, the argument there is going to be, look, stalking is sending emails, making phone calls, following people, etc. They're going to say that by virtue of the fact that in addition to those things, he also filed suits and tried to have them served on people who were the object of the no stalking order, that violates the order?
So the concern from the very beginning, so through most of American history, we have had no criminal laws banning, prohibiting stalking. No criminal laws prohibiting harassment. Through almost all of our history. This is foreign to American constitutional history. In the late 1980s, early 1990s, is when these laws started being imposed in the name of protecting victims of domestic abuse. But that was quickly being usurped by feminists and statists who had other objectives. But from the get-go, courts were concerned that they were going to try to criminalize constitutionally protected conduct, which you can't do. So that if the stalking or harassment charge is based on speech, press, association, expression, petitioning the government for redress of grievances, which includes reporting crimes of other people, whistleblowing, filing lawsuits, serving legal papers, etc., then that's a violation of the Constitution. And so court after court after court found the original stalking and harassment laws unconstitutional all across the country. New Hampshire, Vermont, Colorado, Maine, you name it. So the way the model penal code, the scholars got together, salvaged these statutes. They said, okay, we see what conduct we're trying to deal with. We're trying to deal with very specific conduct, not words, not petitioning. So what they said was, no constitutionally protected conduct can ever be criminal stalking. No constitutionally protected conduct can ever be criminal harassment. And they told the legislatures, put this in the statute itself. So that's why the model penal code says, put in the law, it's a complete defense if you're engaged in constitutionally permitted conduct. So the point is, they want the person who keeps staring at you in the window at 2 a.m., right, in order to scare you, not the person who's serving you legal papers at 10 p.m., not the person whose speech you don't happen to like, right? So if it's the act of texting them, that's one thing. If it's based on the content of that texting, that's a whole different thing. So the second level you salvage the constitutionality of these laws is the true threats law, which we've talked about in many, many contexts. The Alex Jones case and how it was misapplied there. By the way, it's going to relate to one of our later cases. One of the most famous true threats cases is Harry Bridges. By the way, it means the Constitution does extend to non-resident aliens resident aliens in the United States, but non-citizens in the U.S. But we'll get to that. But what they did is, like, for example, in the late 1960s, somebody's at a Vietnam War protest, says the very first thing they're going to do when they get their gun is they're going to put LBJ in their sniper. Right.
Look, I'm tolerant to the freedom of speech argument. That would have crossed my threshold, I think.
I know. The Supreme Court said no. Said that's not a true threat. It said it has to be an extreme risk of it and a highly likely to occur. So this is where true threats jurisdiction applied. So true threats is, I come up to you and say, I'm going to kill you tomorrow. I'm going to do severe bodily harm. And it's a realistic threat. It's not one of those, I'm going to take you down. We're about to hit March Madness. Great time of year, college basketball tournaments here in the U.S. You're going to hear, fan bases attack each other. Say, we're going to crush you. We're going to kill you. Right? That's clearly rhetorical. Right? So it has to be realistic threat that a reasonable person would perceive as likely to cause bodily injury.
If I can, just stop me with the LBJ one. This is in the aftermath of the assassination of JFK, and he says, "I'm going to put you in the." That could not be more true of a threat, except if he had specified the date and time.
Correct, and the Supreme Court said that couldn't be criminalized, even though there was a federal law prohibiting threats against the President of the United States. So because of that, so that's how robust the constitutional protections are. that if you have any stalking or harassment case, the court has to instruct the jury to separate out the constitutional conduct from the unconstitutional conduct, the constitutionally protected from the unprotected. And that requires true threat instruction. That requires constitutionally protected speech, defense instruction. Then the third level is intent. Remember, we discussed this in the Colorado case 2 years ago. Went all the way up to the U.S. Supreme Court. The Supreme Court reversed Colorado. And what happened was these courts were lowering the level of intent. They were saying, well, it's a threat if some reasonable person would perceive it as such, even if you didn't perceive it as such, the defendant. Mm-hmm. And the Supreme Court said, no, you can't put people in prison for things they didn't intend to do. You has to have at least a level of gross recklessness. So those are the three instructions that are required to be given in any stalking or harassment case. It's recommended in the Washington pattern jury instructions within the notes. So like a lot of your pattern jury instructions will lay out in the pattern instructions, the instructions that apply to every case. And then in the comments in the notes section, they'll say, if these facts are present in your case, add these instructions. It's right in the Washington instructions. So it's in the Washington law. The Washington state law says it is a complete defense that if the allegation concerns violating a court order, that the court order was unconstitutional or violated any law or rule, simply like a rule of service or process. The complete defense. Second, it's a complete defense if you are engaged in constitutionally protected conduct. The way they do it is they say the course of conduct component of harassment or stalking doesn't apply or doesn't include free speech or other constitutionally protected conduct. So that was the entire defense for Ben-Shuf. All the allegations, it's very unusual. So, for example, they only have one time that he ever physically saw either one of the so-called victims or was physically present with them. Only once in 4 years. And it was a 1 minute interaction where he asked where his son was. That was literally it. That's not stalking. That's not repeated following for purposes of harassment. All they had otherwise were text asking where his son was at, and otherwise lawsuits. All of the evidence against him was he's filing lawsuits trying to get his son back. He's filing lawsuits trying to get his house back. He's filing lawsuits trying to get his car back. He's sending process servers. In fact, to give you an idea of how insane it was, the other main piece of evidence cited by the prosecutor in closing against Ben-Shuf was that they alleged he sent his son a pizza on his birthday. Pizza on his birthday. So the other defense in stalking and harassment cases is you had any legitimate purpose other than harassment. In other words, do you have some reason to be talking to this person? In other words, why is it, for example, husbands and wives follow each other all the time? Does that mean one of them can be accused of stalking tomorrow?
No, and just to highlight, I mean, to make the distinction clear that it's the substance and not the act, if he were to file a lawsuit that says you violated the contract, you owe me $500, fine. But if he files a lawsuit that says, I'm going to kill you tomorrow, that would be the stalking part. And they're basically saying by virtue of the fact that he was trying to serve lawful, otherwise non-threatening lawsuits or have service affected, that violated or that qualified as stalking.
Correct. They were trying to make petitioning the court for redress of grievances a crime. In fact, the jury was instructed that him reporting other people's criminal behavior was itself a threat, an illegal threat. Can you imagine? I mean, whistleblowing is now a crime in the state of Washington, according to the instruction given to the jury.
What were the actual facts of that specific? Like, I'm curious to even know.
So he reported a bunch of what he considered criminal behavior. Some undoubtedly was, some disputedly was. Let me get to the part that was disputedly was. He considered, what happened is they had his son take the COVID vaccine and get booster shots.
I would qualify that as assault on a minor.
Without the son's informed consent and without him even knowing it was happening. They didn't even tell him any of the side effects. In fact, they lied to the son and told him that there were no side effects at all. Said that the CDC's listed side effects that he had been told about by his dad was fake from his dad. His dad had made it up, even though it was right from the CDC's website. So he considered that criminal abuse of a child, an assault of a child, and a violation of Universal Code of Human Rights. But let's go to the crimes that they undisputedly were committing. The mother of the child had gotten into a relationship with another woman and they go around as global prostitutes. They run a global prostitution ring, is what it appears to me, because they're out promoting other prostitutes all around the world. By the way, none of this evidence was allowed to be introduced. All that was introduced was the fact that he had reported them for criminal conduct. What criminal conduct they reported for, the jury wasn't allowed to know. But what the jury was told is it's a illegal threat to report or tell someone you're going to report their criminal conduct. This means right now Bill Gates could have anybody he wants criminally prosecuted in the state of Washington, because how many people have said that Bill Gates should be referred for criminal prosecution?
Me.
Yeah, a bunch of us. I mean, that's how nuts it was. So that's where the First Amendment in the Constitution comes into place. Right before closing argument, the government asked the judge, said, "Judge, don't allow him to talk about the Constitution in closing argument." And this was part of the jury instructions. The judge refused to give any of them. The judge was so lazy. The judge the judge asked for me to submit my jury instructions. She never read them. How do I know she never read them? Because she was unaware of exactly the language we were objecting to, which was right in our written objection. Not only that, the judge was so lazy, she had never read the government's instructions. How do we know? Because the government's instructions had a bunch of typos in them. The government's instructions had left 4 instructions out accidentally. The instructions failed to include key names and information in them. It included brackets that were supposed to be stricken. The judge had to do that live in front of the jury. The first time she actually read the jury instructions is when she's reading them alive to the jury and discovering all the screw-ups. That's how lazy this judge was. And she's rated at places like Roving Room, one of the worst judges in all of America. And I got to witness it firsthand. She was threatening members of the gallery, threatening me, threatening local counsel, threatening the defendant, all kinds of things. So in the context of this, they say right before closing argument, after they've already got the jury to be completely wrongly instructed on the law, no true threats instruction was included, no reckless intent instruction was included, no constitutionally protected conduct instruction was included, no theory of the defense instruction was included.
So it's basically yet another Alex Jones, Steve Bannon, where there's no possible defense then, because there is no defense anymore.
You completely eviscerate. She eviscerated the evidentiary defense before trial, saying you can't talk about all the criminal activity these two people were involved in, even though it's the number one complaint. And so you think he's crazy talking about it because you don't know what the actual crimes were, when they in fact admitted they were engaged in those crimes on a routine and regular basis and are clearly being politically protected by the corrupt law enforcement in Seattle. And then on the flip side, the legal defense is constitutionally protected conduct. And she completely eviscerated it right before I got up in closing, said I couldn't even talk about it. Not only was it not in the instructions, the one thing I could not mention in closing argument was any reference to the Constitution of the United States. Her exact words were, this is pretty darn close to an exact quote, the reference to the Constitution has no place in my courtroom. That is what a judge is saying in America today. The Constitution of the United States has no place in the Seattle King County Superior Court's courtroom, a courthouse named after Martin Luther King. Martin Luther King is spinning in his grave with how embarrassing the King County Superior Court process is.
Did she, I mean, I don't know how hard you can push it and just repeat it in the list. Did she threaten to hold you in contempt if you did?
By implication. I mean, she was repeatedly doing that. So, for example, earlier in the case, another party who wasn't party to the case filed legal papers and served them on the two so-called victims, which was the mother and the mother's new girlfriend, fiance. Had nothing to do with me. Had nothing to do with Mr. Benshoof. She threatened everybody related to that. And that was the first time I realized they really think filing lawsuits, petitioning the court for redress of grievances is a criminal act. I mean, I was just shocked at I was like, you're kidding, right? And I even said, Your Honor, these people have a right to petition the government for redress of grievances, the right to serve legal documents. They actually have the obligation to serve legal documents. And she's like, well, that's just like your opinion. I mean, literally, that's just your opinion about the Constitution, whatever. That's just like your opinion. It doesn't apply here in my courtroom. I mean, that's the kind of insanity to witness live. And like some people asked, why did I talk about this case? Why did I highlight the case? 2 reasons. One is, this is what's happening in all liberal democratic jurisdictions. And now we're seeing it at scale by the federal courts against President Trump. The point was what was happening to Trump in the buildup between 2020 and 2024, what's been happening to the January 6th defendants, what's happening now to Trump administration is not an anomaly. Liberal democratic courts are trying to stage coups against the constitutional government in this country and trying to eviscerate our constitutional rights and remedies, of which Mr. Ben-Shoof's case is simply one exemplar. The second component is how much is an attack on the family. So they're not only attacking his right to petition the court for redress of grievances, the right to report criminal behavior by others, treating both as a crime. But the other thing this whole case was about is your fundamental right to care, custody, control, and contact with your minor children. The other courts in Washington were unconstitutionally prohibiting him from talking to his own teenage son who was desperate to talk to him. A teenage son who had attempted suicide after he had been excluded from talking to his father for an extended time period. So his father was particularly concerned with making sure his son knew he cared about him. And it has always been a defense in America, and a specific defense in the state of Washington, that if the underlying court order is unconstitutional, you don't have to obey it, and you cannot be criminally prosecuted for it. Here, they're saying they can take away your parental rights and then put you in prison if you protest it. That's what's terrifying. This is not only targeting political dissidents. If Mr. Ben-Shoof had been pro-vaccine, he's never here. If Mr. Ben-Shoof had been pro-mask, he's never here. If he'd been pro-lockdown, he's never here. In fact, the guardian ad litem court official in Seattle specifically said his viewpoints about the vaccines are outside Seattle's mainstream, and on that basis, he shouldn't be allowed to have contact with his son. That's how insane Seattle's getting. Remember, liberal Democrats believe that we should be locked up and quarantined if we didn't take the vaccine, that our parental rights should be stripped from us. Well, they're actually doing it in the state of Washington. And when he's objecting to the constitutional process, they're making that a crime as well. That's how dangerous this case is and how impactful it is. And it's not a coincidence. The same week, the state of Washington's legislature passes bills restricting all kinds of parental rights, trying to make the state the parent instead of the parent. And you have the Democratic House Committee Caucus chairman saying, I'm sick and tired hearing parents say about their right of access, and saying it like that. That's the tone in which he used. This is how nuts. And it's the same week. The Attorney General of the state of Washington is threatening every local cop and sheriff in the state that if they help the Trump administration deport dangerous illegal immigrants, it will be the sheriff who goes to jail. It will be the local cop who goes to jail. If Harmeet Dillon and the Trump Justice Department do their job, there's a bunch of judges, a bunch of prosecutors, a bunch of politicians in Washington who belong in prison. That's who belongs in prison, not Kurt Ben-Shoof. These are rogue judges that have long since forsaken their oath. We only take one oath, and that oath is to the Constitution of the United States of America, and if you're in Washington, the state of Washington. That's it. They're not honoring it. They're not abiding it, and they're so used to abusing power, they're shocked when anybody like me shows up and pushes back at all. But that when you have courts convicting people, like what happened in New York, like what happened in D.C., like what happened in San Francisco, and now has happened in Seattle, where the Constitution is the one thing you cannot reference in a case where the law itself makes the Constitution undisputably a complete defense to the charges, then you know how insane the judicial branch has got.
Okay, people are asking, like, procedurally, what would be the mechanism? We understand Harmeet Dillon, when she gets sworn in, can pursue conspiracy to violate civil rights. It's civil rights. It's in the federal law. And the argument is, and I don't think it's a very tenuous one, that the states are fundamentally and systematically violating civil rights, from due process to excessive punishment to deprivation of other valid defenses. And Tina Peters is another case where I don't know that they actually said at any point in that case that you can't mention the Constitution, but I do know that she was deprived of her defense, which was her swearing to uphold the Constitution, which is exactly what she thought she was doing by whistleblowing on the election improprieties. What's the actual mechanism? Like, how would it technically work?
There's multiple mechanisms available. One, just look at what the Biden and the Obama administration did. Any conservative or other law enforcement group they didn't like at a local level, they used the Civil Rights Division of the Justice Department to crack down on. They've given you the roadmap for exactly how you can use it to crack down on these systematic and systemic violation of civil rights by state actors. So the Civil Rights Division has civil power and criminal investigative power. It has both. And I think a mixture of both is probably appropriate. You can also defund them. It's one thing to be a sanctuary city and say you're not going to voluntarily help. It's quite another to criminalize somebody who voluntarily helps. It's quite another to facilitate aiding and abetting illegal criminal activity in that state. And I think that's what's happening. As Mike Davis pointed out, I think federal judges are now complicit in that. And they're not immune from these laws on aiding and abetting.
Yeah, when we get into the enemies. Geez,
Alien Enemies Act.
Alien
Of
Enemies Act.
1798.
79. When we get into that, we're going to find it's wild what the judge was actually ordering in that.
Yeah, we were forcing the president of the United States to bring a terrorist into the United States.
Well,
to be crystal clear, that's what the judge said. Didn't care. The person was designated a terrorist. Said, you're going to fly him right back here.
They were en route to be deported. I don't know how they circumvented the judge's order without, there being contempt. The planes landed in El Salvador. This is the Trump invoking.
Likely outside of U.S. jurisdiction at the time of the court's order. They moved to stay the court's order, I believe, before it could be enforced. And then it's going to be just a direct constitutional confrontation at some point. But we'll get to some of the judicial reforms and remedies and relief available. But the Civil Rights Division is one part of that. But Congress has a lot of power. The president has a lot of power, and they're going to have to exercise it. Because the reason why I'm putting the Ben-Shuv case on blast is this is happening systematically, but there's not enough corrective remedial action taking place, not enough public outcry by people with decision-making authority taking place. Every conservative or constitutionally oriented legislative or any other level of official in the state of Washington should be screaming bloody murder about this case and other things happening in that state. And they're not with regularity or consistency or putting it on blast to the degree it needs to be. Because most people, when I explain what happened in this case, they're shocked at every level. I talked to left-wing defense lawyers who are shocked. They said it's the worst instructions ever given in the history of any stalking or harassment case in the history of America, what was given in the case of Ben-Shuv. Because no true threat instruction, no reckless intent instruction, and no constitutionally protected conduct instruction, and exclusion of all evidence concerning constitutional activities. For example, petitioning the courts to enforce your right of care, custody, and control of your child is a twofold constitutional right. And then when you're speaking about it to another person, it's a third right. And then when it has religious components, which it did in this case, it's a fourth right that's being implicated. This judge took all of them away and denied him even allowing him to tell the jury about it. That's how nuts it was. So it's where we're getting, and I think that's where Congressman Gingrich, Mike Davis of the Article 3 Project, Senator Mike Lee, Elon Musk are all on the right path. It's time to confront and constrict the rogue judicial branch, the states through the Civil Rights Division of the Justice Department, and the federal courts through many tools that are available. Cutting budgets, they can do the same with local and state governments. These rogue and local state governments that don't want to enforce immigration law, fine. See how well they get by without any federal funds. Good luck with that. State of Washington would be broke tomorrow without lots of federal funds from outside the state. So it's time to start using the power of the purse, using the power of the sword, using the power of the constitutionally authorized power of the presidency to confront this rogue judicial branch, which is trying to stage a coup against constitutional liberties in America at every single level.
It's an interesting thing because I say, like, it doesn't seem that there's enough of an appetite or even an interest. I think that not enough people are familiar with the actual facts in Ben-Shuv. I say it's not a prominent enough individual for people to get outraged. When it came to Alex Jones, Steve Bannon, Peter Navarro, Rudy Giuliani, Donald Trump, then they're like, oh my goodness, I can't believe it. And say, like, this has been going on with other people, smaller people with smaller bullhorns forever. And there doesn't seem to be the appetite.
Extraordinarily egregious within the last 10 years in the Trump era. And so we've got the greatest threat to constitutional liberty in America are rogue state judges and rogue federal judges. The greatest threat to constitutional governance in America is rogue state judges and rogue federal judges. They've got to be hemmed in. And we have a lot of precedents for this historically. So we'll start with Thomas Jefferson. We'll start before that. Some of my old family, in fact, ancestors, in fact, back at the time of the debates around the Constitutional Convention, pretty much every Barnes was part of the Anti-Federalist, because unless there was a Bill of Rights added, we weren't interested. The first Constitution was just a coup. Read Charles Beard's Economic History of the U.S. Constitution. And it was an attempt to usurp all of our liberties. And it was thanks to noble advocates like George Mason, like some Barneses of Rhode Island, and some others that said no Constitution unless the Bill of Rights is added to it. The Bill of Rights is what is the most celebrated part of the American Constitution. There are some other good ideas in the rest of the Constitution, but it's only a redeemable structure of government thanks to the Bill of Rights making certain things crystal clear about the rights of the people, the rights of the states, and the limited power of federal government.
The Bill of Rights drafted by James Madison, or primarily written by James Madison. What did they?
Well, they really came from George Mason from the Virginia Bill of Rights in the late 1700s.
I'm going to ask,
and he deserves more credit than Madison, to be frank about it.
Okay, what was his name again?
George Mason.
Okay,
so the George Mason University, still in the state of Virginia.
I want to ask a stupid question then. I mean, what did they import over from England? What did the England have by way of the equivalent?
To a degree, the Virginia Bill of Rights and the Pennsylvania Bill of Rights and the Pennsylvania Declaration of Constitution, which both informed the U.S. Bill of Rights, do derive going back 6 centuries to the Magna Carta.
Okay.
Certain principles of trial by, but like the Anti-Federalists pointed out, the judicial branch has too much power in Article 2. They're like, there need to be better restraints. These judges are going to abuse their power. Because remember, originally, jury trials were not protected in the original Constitution. That only comes from the Bill of Rights. The Bill of Rights says you have to do trial by jury in civil cases. You have to do trial. They had trial by jury for criminal cases in the substance of Article 2, but only the amendments add jury trial rights for civil cases. But they said, look, here's all the risk you're going to have if you let this elite body of politicians have concentrated power. And their concerns came to fore right away. And the Judiciary Act of 1801, the Federalists got whooped in the election as they deserved to. Thomas Jefferson won. By the way, Thomas Jefferson, as vice president, decided an electoral dispute that made himself the president, just FYI. For those that say, oh, there was no such constitutional history of that. Yeah, it goes right back to the very founding of our country as to the power of the vice president in that role. But what happens is on their way out, the Federalists say, let's stack the courts. So they create a whole bunch. They reduce the number of justices on the Supreme Court. Where have we heard that before? They go in and they expand the number of circuit courts. They expand the number of district courts. They appoint a bunch of midnight judges. And what do they do once they get that power? Well, they immediately run in and try to criminally prosecute all the people they don't like, all the anti-federalists, all the new Democrat Republicans of the Thomas Jefferson presidential election that represent the ordinary person and the true civil rights believers, civil liberties believers, individual liberties believers that were part of our elected structure of governance at the time. And Jefferson has some beautiful, beautiful quotes about the nature of judges and the nature of the judicial system. You can go back and watch it. So if anybody tells you, oh, our founding fathers wanted the judges to rule all over us all the time, and they're philosopher kings who are much smarter and brighter than us, and John, they said, McCulloch versus Maryland, Read what Thomas Jefferson thought of the McCulloch versus Maryland decision. I'm on the Jeffersonian side. But what do? They go and pass the Judiciary Act of 1802 that says, you know what? What you did last year, screw you. We're putting new courts in new places. We're getting rid of the courts that you try to put in certain places. We're changing budgets. Every Supreme Court justice, you're going to get off your rear and you're going to ride circuit across the country. So they restored what the first group tried to do in weaponizing it. The next year, they still weren't getting the message because Supreme Court Justice Samuel Chase was running around and weaponizing his judicial power, because back then Supreme Court justices even presided over trials. And he was targeting the political opponents and said so explicitly to grand juries. So Thomas Jefferson said, Congress, doesn't this seem sort of seditious, sort of bad behavior of Supreme Court Justice Chase? And Congress is like, yeah, you're right. And they impeached Supreme Court Justice Samuel Chase, and he came within an eyelash of getting removed. Because remember, federal judges, unlike everybody else, can be removed for simply not engaging in good behavior. Don't have to prove a crime, no high crime or misdemeanor, none of that. Not for judges. You can remove them for simply not engaging in good behavior. Violating your constitutional oath is the sine qua non of bad behavior.
Not engaging in good behavior both on and off the bench, or specifically on the bench?
Period. It's broad. It says during good behavior, you get to stay a judge, but only during good behavior. That is a broad brush. And so what happens? Chase survives, but he gets the message, and all of his pals get the message. In between the major budget changes that changed which judges had money and which ones didn't, which districts they had jurisdiction in and which ones they didn't, all of those key core changes that took place as to how many judges even existed in a certain area, they all of a sudden they backed off for a good long while until Andrew Jackson. And one of the judges appointed by those exiting Federalists was that corrupt hack, Justice John Marshall, Chief Justice John Marshall. You go to law school, like, oh, the great Chief Justice John Marshall, McCulloch versus Maryland, usurped the power to declare. He said, only us on the Supreme Court, only the philosopher kings anointed and appointed to these positions can decide what is and isn't the law, what is and isn't the Constitution. There's no basis for that at all in the Constitution itself. No basis for it in Congress's authorization either, which is given, Congress is given plenary power over the court systems below the Supreme Court of the United States. Give you an idea of how Thomas Jefferson smacked him around. He canceled an entire term of the Supreme Court. He said, nah, I don't think you need to meet this year. You can get together next year if you're going to engage in these kind of shenanigans and try to overthrow a presidential election. So if everybody says Trump can't do this, Thomas Jefferson did a lot more. So they come back around to Andrew Jackson, and it's Chief Justice Marshall who actually puts in motion the denial, the Indian removal, even though he'll try to opt out of it and push it back onto Jackson later on. What happened is, there's a land dispute that arises out of Ohio, in the Ohio territories. And the issue is, who has legal title? One group acquired legal title directly from the tribes who occupied those lands and were recognized as the sovereign over those lands at the time in which title was given to them. Another one was given title to a successor who had no such claim at the time. However, dear Chief Justice John Marshall had most of his estate tied up in the latter category of land grants. So what do you think Chief Justice Marshall decides, this orator of the law, this diviner of the Constitution? He decides that there's no such thing as Indian tribal land. Then Indians, Native Americans, they don't got no idea what land is. They don't know what it is, wandering around doing crazy things. The smoking their peyote. So they don't have a concept of land ownership. As my old Indian law professor Richard Monette would say, nothing did more damage to Indian tribes in America than Indian-loving liberals. And Marshall was the origin. But of course, he didn't disclose his massive conflict of interest that he lined his pockets, because by Indian tribes not having recognized legal title, he made sure that his legal title was guaranteed and all his riches secured. It's based on that doctrine that Georgia takes away certain Cherokee Indian tribal rights in Georgia that leads to Indian removal, that then he says, oh, I'm not sure about that particular act that leads to Indian removal. It started with Marshall himself. But the other dispute that all the liberal historians don't like to talk about is the Second Bank of the United States. Just like Thomas Jefferson, Andrew Jackson was not a fan of a centralized banking system. He said all it will do is enrich and profit an elite class of banksters at the expense of the American people. And he said to him it was clearly not constitutionally authorized. Supreme Court disagreed. And it was more in that context than the later Indian removal context to which it would later, almost a half a century later, be attributed to. It was actually in the Second Bank of the United States context that Jackson said Marshall's can make his decision, he can enforce it. So there's the Jacksonian direct challenge to illicit actions by the judiciary. The next major challenge involves FDR, the liberal Democratic hero, who, when they were striking down the New Deal, FDR came out and said, I think the Supreme Court is really busy these days and they could really benefit from some more judges. So I'm going to put about 6 of them on there. All of a sudden, the Supreme Court stepped back, said, the New Deal is just fine now that we think about it. And so anybody who tells you there hasn't been a long history of contest between the branches of power that date to the origin of this country, that date to the very concerns the wise anti-federalists raised during the constitutional conventional debates, will be lying to you. The Congress has extraordinary authority. Congress can take away the jurisdiction of any court in the country below the Supreme Court. They can eliminate it if they want to. Eliminate it entirely. They can restrict their jurisdiction any way they want, anytime they want.
But by what percentage of a vote would have to be achieved in order to?
It's majority. It's majority vote out of Congress. Congress is given this pure legislative plenary power over the court systems below the Supreme Court of the United States. Plenary power they exercised in the Judiciary Act of 1801 and the act that reversed it in the Judiciary Act of 1802. So from the very founding of our country. For example, they took away the District of Tennessee and added a District of New York. The Jefferson comes in and says, screw you, we're taking it away from New York and we're giving it to Tennessee, right? It's all of those things. The geographic power a court will have, the substantive power the court will have, the procedural rules the court must obey, how appeals can be done, whether Supreme Court sessions even happen, all of those within the control of Congress. The second structure that Congress has is the power of the purse. They can just defund the judicial branch anytime they want. See how long these judges are so super proactive if all of a sudden they lose their clerks and secretaries and all the other patronage they've been liberally afforded over the last half century or so.
And just to flesh that out so people understand, you could not defund the judges themselves, but rather aggregate budgets that go to other things other than the judge's salary.
Right. Everything except the judge's salary. Judge's salary you can't change constitutionally. Everything else you can. And just because you're paying the judge's salary doesn't mean you have to give him any power. You can give him zero power. As, by the way, has happened in the past. Go back to the founding of the country when they took away power from some judges and gave it to others. I mean, they did that routinely. They reassigned judges. They said, by the way, this circuit doesn't exist anymore. Now this circuit exists. You're going over here. So, maybe all those D.C. judges, I think Juneau, Alaska is a beautiful place. I think passing a law that requires all judges from the District of Columbia reassigned to the District of Alaska and that they have to be there in person. They have to physically reside there. There's actually a law on that. And they could expand that law. And there's some other wonderful little places that they could send them across the country to give them a proper education. So they can change all of their jurisdictional powers through Congress. They can change their budget at any time they want. Then the third thing they can do is, as we've talked about, is they can impeach and remove them. And even if you don't think you can succeed in removing them, the history is simply impeaching them wakes them up. I woke up but you pick a couple of high-profile ones to wake up. And the problem in terms of state court systems, the problem after the Civil War was state judges and state law enforcement was conspiring to systematically steal elections. Where have we heard this before? Judicial complicity in stolen elections. And suppression and denial of civil rights and civil liberties and weaponizing legal system for lawfare against political dissidents. In other words, all the things we're experiencing right now happened between 1866 and 1890 in the Deep South. And that's why we passed the Civil Rights Act of 1871. That's why the 14th Amendment went through. It was to stop rogue state judges and state law enforcement from systematically violating the civil rights and civil liberties of people within their jurisdiction, most commonly for political purposes. And you might think it was only being used against ex-slaves. Not true. In 1900, there were fewer voters in Mississippi than there were in 1860. That isn't because any slaves were voting in 1860. The white population had doubled in that time frame, and yet the vote went down. Why? Because they systematically denied poor and working class whites, as well as any dissident, the ability to access the election political system. So it was the wholesale, whole-scale disfranchising of the American population that the civil rights laws empowering the Justice Department were designed to correct, remedy, and prohibit. So Harmeet Dillon, who should be confirmed within a week or two at the Civil Rights Division of the Justice Department, Pam Bondi already there, Kash Patel already there at the FBI. I mean, at least they're taking some corrective action at these politically motivated swattings that are occurring. I mean, we have an InfoWars reporter shot down dead outside the front of his house. And the only thing all the people have in common that have been swatted or have been literally murdered, like that reporter was, and there's a give, send, go for his family that you can help and look up. That we'll link here. Is that they are on the Ukraine hit list of U.S. aid funded, by the way, Ukraine hit list. Money went from the U.S. taxpayer to U.S. aid to a Ukrainian media organization, NGO, that put Americans, including the Vice President of the United States, on a hit list. And now several of them are being killed. This is, assisting Jamie White's family. Jamie White, investigative reporter for Alex Jones at InfoWars, murdered outside the front of his house. And the only thing he has in common with the other people that have been targeted for swatting and other events like that is that he was one of the top people on that Ukraine hit list, who our current Vice President, J.D. Vance, is still on that hit list. That's how insane that is. But for when you have these rogue state actors, when then you use the civil rights power that the FBI has. Go back and watch Mississippi Burning. Well, what's that about? The FBI investigating civil rights violations in the Deep South. Now the civil rights violations are happening in liberal democratic jurisdictions. They're happening in D.C., they're happening in New York, they're happening in Chicago, they're happening in the Twin Cities, they're happening in Washington. They're happening in California, they're happening in Oregon. Those are some of the most egregious examples. They're not the only examples. Happening in Austin, Texas, happening in Atlanta, Georgia, happening in conservative jurisdictions with liberal state capitals and liberal counties, and that it's happening systematically. So what needs to happen is a wholesale effort by Congress to completely restructure and reform the judicial branch and what power it has and doesn't have. Use its power of the purse to take away a lot of money from the judicial branch that has shown it cannot use that money in a constitutional manner or to enforce constitutional principles and precepts. Get rid of the District of Corruption, get rid of the Southern District of New York, start reassigning judges en masse, give a right of any individual defendant to transfer to the venue of their residence or citizenship, any case, civil or criminal, and start to substantively limit the power of federal courts and shift that power to juries, which they can do, shift that power to states, which they can do. And then as it relates to the states, and start impeaching several judges. Impeach this rogue judge who said you have to import terrorists. Impeach the federal judges who issued insane politically motivated rulings against President Trump when he was when he was ex-president in New York in that crazy bogus rape case. Impeach Chief Judge of the District of Corruption, Powell, who's always been insane, who's done. I mean, Julie Kelly has gone into great detail how so many judges in the District of Corruption routinely and repeatedly and flagrantly violated the constitutional rights and liberties of Americans. Just pick some of them from across the country that are the worst bad faith actors and bring impeachment proceedings. The ones that have engaged in criminal conduct, indict them. There need to be some indictments. There need to be some impeachments. Even if the impeachments, you can't get them removed, at least go through the process of impeaching them and forcing them to answer to the inquiry in the Senate. Take corrective protective action. Otherwise, we're running into a direct constitutional confrontation. That is, and this is all because Justice Roberts didn't do his job and Justice Barrett is a traitor. They'd done their job, the courts would have already been disciplined and wouldn't be doing this stuff.
Well, you say that and it's true, except even in the Bruin decision where the Supreme Court does render their decision on Second Amendment rights, you still have state courts overtly violating it and then similarly saying no constitution here.
Think about the arrogance you have to be Judge Parisian in Superior Court of King County in Seattle, Washington, to say in front of a group of onlookers that you as a judge are skeptical of what you're doing. You're not going to talk about the Constitution in my courtroom, Mr. Barnes. I mean, think about the arrogance that requires. I mean, that's what should scare people. This isn't just about violating civil rights and civil liberties. is that it's the arrogance that comes with it that they think there will be no bad consequences to them for their rogue behavior.
I'm
That's
such
why
an
there
idiot.
has to be consequences, or we're in serious, serious trouble.
The judge's name, if this is the judge, Suzanne, I'm not trying to...
Judge Suzanne Parisian. You can look up on Robing Room, and if you think, hey, Barnes is just exaggerating, go to Robing Room. A bunch of people that come from across the political spectrum, one after the other, reviews her as one of the worst judges they've ever dealt with.
Well, first of all, when you say arrogant and pompous, her last name means Parisian in French, Parisien, which is quite funny. Speaking of arrogant and pompous, I'm such an idiot. I was still thinking it was the other judge. I don't want to make a mistake on her name.
The crazy sentencing.
The crazy that I thought when
it was also nuts.
Yeah,
their willingness and readiness and eagerness to systematically violate the rights of dissidents, for the state to take over the role of the family, to make it a crime to report other people's crimes, to make it a crime to simply petition the court for redress of grievances, including asserting your constitutional right to parent your own child. This should be shocking to people. Some of these things have never happened at this scale in the history of this country. And that there has to be protective, proactive action now, or we're going to be stuck with a very dangerous system. Yeah, I mean, you can look it up. She has the lowest possible rating of any judge.
She's a disgrace.
And every lawyer, one after the other, every litigant that's ever dealt with her describes her as one of the worst judges they've ever dealt with in their life.
This one might be related to the ongoing... No, it can't be related to the ongoing
because
trial.
It's a government litigator who's talking about denial of rights of women. So that she's just biased, period. That she's not competent to be a judge, period. But liberal advocates are putting these kind of people on the bench because they'll do the liberal agenda.
Let me just read a couple of these. This is fantastic. She's a disgrace to the legal profession, malicious, erratic, sociopathic, and incompetent. Doesn't read a word of the pleadings or listens. Go down. This judge is objectively terrible, does not belong on the bench, as many of my colleagues agree. She's biased and lazy, clearly conducting no legal research. Next one. I do not think she read the files. Next one. It is unfathomable how such a morally depraved individual could be appointed a judge. A pure psycho. She should be...
And ask yourself, how is this judge on the bench for 13 years? A decade plus? Getting prime gigs and prime cases? How is that even happening? It's happening because they're serving the ideological agenda of the liberal Democratic Party. And that's what's terrifying. And when we're to the place that they thought they could lock up and bankrupt the past and future president of the United States, that should have been a screaming warning sign to normie conservatives. But clearly it wasn't. I mean, it took rogue action after rogue action by federal court after federal court for finally Senator Grassley and others to say, hold on a second, we do got to do something here. And I get it, Senator Grassley and others don't want to, throw out everything, but you got to look at, this is getting insane. I mean, when you have federal judges who think they get to decide what's classified and what's not, they get to decide who gets to keep a secret and who doesn't. They get to decide who has access to classified material and who doesn't. They get to decide who gets to come into the country and who doesn't. They get to decide how money is spent or how it isn't. They get to decide who works for the executive branch or who doesn't. They have long lost the script. They need to be impeached, indicted, removed, withheld of power, budget taken down, every reform available. It's time that every possible proposal is on the deck. Roberts had his chance. Chief Justice Roberts blew it. He had a chance to save the court system. He failed. So now, Justice Roberts, you're going to lose a lot of the power in your court system. Get rid of the FISA court altogether. It's never done anything constitutional or conscientious. Is it really a coincidence that the federal judge ordering Trump to import terrorists and give money to foreigners was on that FISA court that unlawfully and politically allowed illegal spying to occur of President Trump?
Hold on, let's save this one for when we get into the details on Rumble. Robert, I'm just going to screenshot and share some of those judges' reviews. Those are hilarious. Everybody, start making your way over to Rumble. We've given more time than we needed to CommieTube. There's 3,500 people. Get your butts on over.
One last component while we're still on the CommieTube. So people have been asking as part of the new Rumble lineup, you're going to be on every day at 4 p.m. Eastern, I believe.
Yes.
That's a Monday through Friday. Our show will stay at
absolutely. Yeah, no, our show stays on
Sunday.
Sunday, and I'm going to ask for some modalities because it's going to figure this out because I don't want to, on the one hand, step on other people's toes who are going to be live at the same time, but I'm going to start doing pre-recorded interviews. No, but so my weekly daily show will no longer be at 12:30. It's going to be at 4 to 5-ish. And then we'll have our local stuff afterwards, and people will go and continue watching if they're so inclined on Rumble. Except this week, exceptionally, because the quartering is keeping his original time, I'll be at 3 o'clock. So it's going to be phenomenal and amazing. What was I about to say? Holy cow! I'm just reading some of those.
Taking odds on whether the judge tries to lock me up on my birthday in Seattle.
Can you do it remotely? Hold on. Let me read a bunch of the Rumble rants over on Rumble before we get out of here, or at least go over to Rumble. Sad Wings Raging says McCarthy was right. Just look at our judicial system to see the truth in that statement. Randy Edward, argument is the judge did not put his order in writing. This is Wanora, says judges have aided and embedded the use of forged documents to foreclose on millions of homes in the USA since 2005. King of Biltong in the house says, looking for some healthy snacks to add to your diet. Try our Biltong, almost 15% protein, packed with B12, creatine, iron, zinc, and much more. Go to BiltongUSA.com. Code Barnes for 10% off. Jeffrey French Pads says, commie's gonna commie. I won't read the rest of that. Winora says, I was told by an otherwise nice and cordial but harried older judge in Minnesota, more sincere than MN nice, during the farm crisis not to bother him with the Constitution because he had enough problems. Barnes, can Trump use an administrative furlough to downsize government agencies? Sportfish 177. Ask Barnes if any of these judges' decisions can override a president's executive order and how they get away with it. In a second, we're going to get there over on Rumble. Would you be willing to host a Crowder or Crowder's lawyers bill? For sure, I'd be. In fact, now that I'm going to be mingling with...
We've invited both Crowder and Half Asian Bill, as he's colloquially known, or as Crowder calls him, on the show anytime. Happy to do a crossover. Happy to be on with them.
Absolutely. And I think we can make that happen sooner than later, because now that we're all going to be part of one daily lineup. Trump can deport bad guys even without the Alien Enemies Act. So what's the advantage for using it? The act, Cheryl Gage. Hold on, we're going to get to that right now. V6 Neon. As of midnight here in the UK, we'll be in a position where any media platform could be fined a percentage of their global revenue for what USA would be First Amendment. Free speech gone in the UK. Online Safety Act includes jail. Sounds like Canada. Question that I posted on the video you posted earlier. Could those gang members be classified as invading combatants due to them being classified as terrorists? Hold on. Rivka the Jade Gamer. Media Matters for America. Wonderful organization. Eye roll. And that's it. Okay, then there was one question over on... hold on. I had one that I screen grabbed on CommieTube. Hold on. It's in the backdrop on my... unless Encryptus sent it to me. Let me see here. It was... I forget what it was. Hold on. Let me bring it up. It's in the backdrop
For those
here.
asking, the book is John Grisham Framed. It's a true story. It's a collection of a bunch of real people who are completely framed by our legal system. So, and it highlights the common themes that you see with a lot of those kind of cases. And it's but the problem is becoming more egregious because of the political prejudice of many of our courts.
Viva is easily the best guest on that list. Fight me, says Jay. No, so this one was Matthew Hammond over on CommieTube. Today, 41 years ago, Gary Plosh did nothing wrong. Gary's ex-wife said she would have driven Gary to the courtroom if he told her what he was going to do. That was the guy who took out the individual who abducted and did bad things to his son in the videos.
Imagine, you think something's wrong with your son, you go to the court system, and that's what they put you in prison for a decade for going to the court system.
If I God, this is not a fear hiding a wish. This is just a fear. And what would happen if I found out that someone had administered something to my child without my permission? It would never have happened. It wouldn't be a family law issue. It would be like a school doing it when the kids when they don't tell your parents. There would be a very, very, very big problem. With that said, now everybody get your butts on over. We're 3,000 on CommieTube, 24,700 over on Rumble. Get that. I want to pull a Matthew McConaughey. Those are rookie numbers. Get those numbers up. I'm joking. Thank you all for being here. CommieTube, come on over, and I'll put some clips from the remaining portion tomorrow on CommieTube. Updating now. See you there. If you're coming, the link is in the pinned comment. And if you're not, see you later, peeps. We're going to Rumble and Locals. Bada bing.